Okay, I'm just waiting for the jail to connect with the defendant, so if everybody could just remain on the line, please. Sarah, are you there?
Judge, I am.
Can you give a call down to the jail real quick?
Judge, I think there was some confusion on this because I think everybody assumed that this was in front of Judge Burmeister. So give me a moment to call the jail and we'll get him on.
Okay, sounds good. Thank you.
Okay, great. Thank you. Judge, they're on their way to bring him in.
Okay, thanks.
Yep.
There it goes.
Got it?
All right, Mr. Law, are you able to hear me okay?
Yes, Your Honor.
Okay, we'll go on the record. This is People versus David Allen Law. This is Crawford County District Court Case 24-17615-SM-1. The record should reflect Mr. Law is present today by video from the Crawford County Jail. If I could have counsel put your appearances on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Trush appearing on behalf of Mr. Law.
All right, and I believe we have Ms. Norgon from the probation department, is that correct?
Yes, Your Honor.
Okay, Ms. Norgon, you're the supervising agent for the district court probation of Mr. Law, is that correct?
Correct.
Okay, so we're on the record here today for purposes of arraignment on a probation violation. Mr. Law, you understand that you're alleged to have violated your probation in your district court case by having contact with the victim. Do you understand why you're before the court today?
Yes, Your Honor.
Okay. A couple of things I need to go through with you with regard to your rights on the probation violation. You do have the right to have a hearing as to whether or not you violated your probation. You have the right to have any an attorney present at any subsequent proceedings. If you can't afford an attorney, one would be appointed for you at public expense. Mr. Trush is present today for purposes of arraignment to represent you. If you have any questions or you'd like to talk to Mr. Trush at any point during this hearing, please let me know and I can facilitate that. If you are found guilty of violating your probation, Ms. Norrigan, what's the maximum penalty on this underlying charges?
I believe 93 days.
Okay. Mr. Law, do you understand all the things I've just stated to you?
Yes, Your Honor.
Mr. Trush, have you had a chance to talk to Mr. Law about how he wants to plead regarding the probation violation?
Your Honor, this is just the misdemeanor case, not the felony bond violation that we're dealing with right now, right?
Correct.
Yes, Your Honor. I did discuss the matter with him. He had indicated that he would admit the violation today. I did discuss with him his right to have a contested hearing, and he wanted to admit the violation.
All right. Mr. Law, is that correct?
That's correct.
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can lower your hand. Mr. Law, you understand, again, that by pleading guilty to this violation, you're going to be giving up the right to have a hearing?
Yes, Your Honor.
And again, that the maximum penalty you could face would be up to 93 days in jail for violating your probation. Do you understand that?
Yes.
With that in mind, what is your plea to the violation today?
Guilty.
Has anybody threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything?
No.
Is it your own free choice to plead guilty?
Yes.
Are you pleading guilty because you did violate your probation?
Yes.
All right, back on April 12th, a couple days ago, were you on probation out of the district court in Crawford County?
Yes, Your Honor.
Were you aware that one of the conditions of your probation was that you were to not have any contact with Amanda Hall?
Yes, Your Honor.
On or about that date, did you have contact with her in violation of your probation?
I did.
All right, thank you. The court finds that the plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that Mr. Law did violate his probation. The court will accept the guilty plea. In terms of sentencing, Mr. Trush, how do you want to proceed on that?
I would leave it up to the court's discretion. I am prepared to speak on the matter today if the court were inclined to do that, or if the court were to set it for a different date, we would appoint an attorney for that sentencing.
All right, Ms. Norrigan, are you prepared to go forward with sentencing recommendation today, or do you want to have the court set this for a later date?
Well, Judge, we can, but we do have a hearing next week as well on another probation violation for no contact or violating the no contact order. So I didn't know if it made sense to do it all next week with
Okay,
that hearing.
all right, then I agree. I mean, I think we should have all the violations disposed of one way or the other, and then the court will conduct sentencing on all matters at the same time. So we'll set this for sentencing hearing next week, along with the probation violation that's currently set for a hearing. And we'll go forward at that time. Mr. Trush, anything else that we need to address on the probation violation part of this?
Your Honor, since we're gonna set this out a week, I would ask to address bond on the violation.
Okay, what would you like to say regarding bond on his probation file?
So in regards to the probation file, Your Honor, it's a misdemeanor offense. He reports to me that the contact is incidental and driven by contact with his children, which is to say the violation he reported to me was him trying to have contact with his children, not the protected party. Obviously, there's better ways that he could do that. I would suggest to the court a relatively low cash bond would be appropriate given the circumstances.
All right, Ms. Norrigan or Ms. Koch, anything you'd like to say on that?
Yeah, it's my understanding that the children also have a no contact that's in the felony file. We haven't addressed that yet this morning, but you know, he has a domestic violence case, and now he has a felony case that involves home invasion first and aggravated stalking. And while doing all of those things, he still manages to continue to violate the bond. Frankly, I'm not really sure what conditions we can put in or what ways we can tell him that this behavior is just not acceptable. This wasn't a violent interaction. I understand he may want to talk to his children. There definitely has to be other ways to address this because this is just a continued pattern of behavior. So I defer to the court as to what they think is appropriate given all of the circumstances.
Thank you. Ms. Norrigan, anything you wanted to add?
Nothing further.
All right, so I do have some information based on the police report that was filed. Mr. Laws obviously admitted making contact with Ms. Hall. I've been presiding over these two cases for a bit here, and one thread that I think has run consistently through here is Mr. Law continues to have contact with the victim in this case as it relates to both files. And this has been a consistent pattern. I don't accept that it's a de minimis or incidental contact based on contact with the children. I think Mr. Law is purposely disobeying the orders of the court, and my tolerance of that is at an end. He's admitted responsibility for the probation violation. He's going to be sentenced next Monday, I believe, is when we have the hearing set, along with other violations. And so I think Mr. Law has used up any leniency he would have with the court in terms of excusing his continued violations. So the court is going to order that he be held without bond pending sentencing. And again, we'll proceed with that on Monday. Moving on to the felony file, which the court did address by way of a written order yesterday, that dealt with a bond violation. The court revoked his bond on the felony file, which is file number 255382. And the court indicated in that order that it would have a bond hearing at its next available date. So as to the felony file, and for the record, that order indicated that Mr. Law was to be held without bond pending further hearing in the felony case. So Mr. Trush, anything that you wanted to say regarding bond in that file?
Regarding bond in that file, given the court's order in the other file, in the misdemeanor file, no, there's nothing I would add to that.
All right, Ms. Koch.
I have nothing to add. I think we've addressed all of the issues.
All right, the court is going to order, for the reasons that I've just stated, that Mr. Law's bond continue to remain revoked in the felony file. If it's not set for hearing are ready, along with the district court probation violation next week, the court will set the felony file for a status conference at that same time so that we can address both files together.
So his
Yes.
file on this case is set for Monday at 1:45 for a jury status conference.
Okay, great, perfect. So it's already on the docket. So we'll address Mr. Law's cases further on Monday. Ms. Coe, anything further that we need to address from your side?
No, thank you.
Mr. Trush?
I would just indicate, for the record, Your Honor, Mr. Vernon, I think, appointed now in the felony matter. He will also be appointed to handle the probation violation.
Okay, and I believe I may have signed both those orders this morning, substituting counsel, having Mr. Vernon assigned to the case, both of them. Okay, thank you. That's all for the record today. All parties are free to disconnect at this